Good evening and welcome to the Eisenhower Presidential Library and Museum. Thank you for joining us for our Evenings at Ease program. I'm Joy Murphy, your host for the evening. If this is your first time joining us, our 2023 annual theme is Difficult Decisions. All year we've been exploring tough decisions made during the Eisenhower administration. Tonight we are pleased to welcome Rebecca Proctor with the National Labor Relations Board. She will be talking to us about the Taft-Hartley Act. Rebecca, welcome and thank you for joining us.
Thank you. And good evening, everybody. My name is Rebecca Proctor. I am a senior field attorney with the National Labor Relations Board out of the Overland Park office. So we are part of Region 14 of the National Labor Relations Board. I am a labor practitioner and have been in labor practice since 2011. I joined the board in 2017. For those who are not familiar with the National Labor Relations Board, we are an independent federal agency and we enforce only one act, the National Labor Relations Act. That is the act that gives employees the right to join collectively for mutual aid or protection to improve their working conditions. And they can do that either with or without a union. When you hear about the National Labor Relations Board in the news these days, it is most commonly associated with unionization efforts. But it's important to remember that even employees who aren't in unionized work environments do have rights under our Act, as long as they are private employees who are non-supervisory, non-confidential employees. So why are we limited to the private sector? Well, that's one of the things we'll be talking about today, because the National Labor Relations Act is a federal law passed by Congress, and Congress's abilities to pass laws for labor tend to relate to Congress's ability to regulate interstate commerce. That's why we deal with private sector and not public sector employees. I will tell you up front, I am not an Eisenhower scholar. I'm a labor law geek. So I will take your questions at the end. Hopefully, I will be able to answer all of your questions. And if not, hopefully some of the Eisenhower scholars that might be with us can provide some help on those. So before we start talking specifically about Taft-Hartley, and when it comes to tough choices or difficult choices, one of the choices that Eisenhower had to deal with very early in his first term was how to deal with some of the labor unrest that had been occurring in the country. So before we get there, we really need to understand the landscape that brings us to that first Eisenhower term in I think I said 32, I meant 53. So 52 and 53. So when we start looking at American labor history and the American labor movement from 1877 to 1947 in the US, it was considered one of the bloodiest and most violent labor movements across Western nations here in the US. And why do we start with 1877? It's because 1877 is when we had what is now referred to as the Great Railroad Strike of 1877. And it began on July 14th in Martinsburg, West Virginia, after the Baltimore and Ohio, the B&O Railroad, cut wages for the third time in a year. It was the first strike we experienced in the US that actually spread across multiple states. It lasted for 52 days and only was put down because unofficial militias, the National Guard, and federal troops were called in to break up the strike. Because of the economic issues and pressures on wages by the railroads, workers in New York, Pennsylvania, Maryland, Illinois, and Missouri all went on strike. An estimated 100 people were killed across the country as part of this strike. And in Martinsburg, Pittsburgh, Philadelphia, and some other cities, workers actually burned down and destroyed physical facilities related to the railroad. So this was a pretty big strike. And that's what we mark as the start of these big strikes that led to labor law being passed in this country. So, why were we so bloody and violent compared to some of the other Western nations? Scholars have a lot of different theories on that, and there is no real consensus. Some people say it's because our unionists were more militant. Others say it's because people on the employer side actually hired like violent insiders to come and stir up your strikers or to provoke the strikers to violence to discourage strikes. But no matter how you slice it, everybody played a part in the violence. Employers, unions, everybody took part, and it had some fairly serious impacts. When you did see labor laws being passed as we go into the 1900s, they did tend to deal with very specific groups or issues. For example, there was Wick's Bill, which involved child labor law, and the Adamson Act, which actually established the 8-hour workday, but it only applied to interstate railroad workers. We find our first steps towards labor peace taken by President Woodrow Wilson when he created the Tripartite War Labor Board in 1918. That board had no enforcement powers, but labor and management agreed to refrain from strikes or lockouts as a result of its mediating efforts. The War Labor Board, though, did do one very, very important thing. It recognized the right to organize in trade unions and to bargain collectively through chosen representatives. But labor peace was short lived, and labor strife started anew after the 1918 armistice. And hostility between labor and management ran very high in the 1920s. So, this was the era of using labor injunctions to stop strikes. The Railway Labor Act, which stressed the importance of collective bargaining to minimize strikes and lockouts on the railways, passed in 1926. So, why do we think all these movements start with the railways? Well, the railways were a very important way in this period of moving goods and people across the country. So, as the railroads went, so went or did not go the produce, the people, and the other goods that would be grown or produced in one area of the country and moved to another. In 1932, during the Hoover administration, Congress passed the Norris-LaGuardia Act. That curbed the power of courts to issue injunctions or restraining orders against strikes, absent cases of violence or fraud. Congress then declared it was the policy of the United States that workers were free to join unions and engage in collective bargaining with their employers. So, what do we mean when we talk about collective bargaining? Collective bargaining is the process by which groups of employees gather together and bring their proposals, their complaints, their conditions to management. It's not a one on one conversation with management, it's done by employees as a group. Unfortunately, that policy statement did not stop labor unrest. There was a renewed interest in organizing. Employees wanted to join unions, but a refusal on the part of many employers to recognize employee unions, which led to strikes in support of unionizing drives. When we think about the strikes we see today, and if everybody watched the news tonight or heard the news today, you would have heard that city employees in Los Angeles did a one-day strike today to shut down city services. And we know that we have strikers from the writers union and from the actors union. Those are all established unions. We don't tend to see a lot of strikes that are in support of union organizing. Though we have the last 2 years, employees from Starbucks have done strikes, they've done pickets in support of organizing. But the strikes we see, much like those Starbucks strikes, much like the strikes by the group Fight for 15, who are fighting for a minimum wage in the fast food industry, they tend to be very limited term strikes. We don't in modern times see these long-term strikes that are conducted for the purposes of being able to form a union. And part of that's because of the labor policy that we'll be talking about today. So in 1933, President Franklin Roosevelt created a national labor board, and he made Senator Robert F. Wagner its chairman. The National Labor Board didn't really have a lot of power, but it managed to settle 1,109 strikes, avert 498 others, and settle 1,800 other labor disputes. Despite those numbers, workers continued to be unhappy, strikes continued to occur. In 1934 alone, longshoremen in every port on the West Coast walked out on their jobs. 2 strikers were killed by police. There was a general strike of 150,000 workers in the San Francisco Bay Area. Teamsters in Minneapolis shut down transportation of goods for 2 months, forcing the governor to call in the National Guard. Later that year, 10,000 auto workers in Toledo, Ohio went on strike. And during the summer of 1934, 400,000 textile workers from New England to Georgia also went out on strike. In response, in 1934, Congress passed Joint Public Resolution number 44, authorizing the president to establish a new board called the National Labor Relations Board, which we now refer to as the old NLRB. It was composed of 3 public members, and its decisions started providing the foundation for a basic American labor policy. Then in the fall of 1934, Senator Wagner began revising a bill regarding labor disputes to try to find a solution to the enforcement issues that had plagued earlier boards. In February 1935, Wagner introduced the National Labor Relations Act, also known as the Wagner Act, in the Senate. The bill created a new independent agency, the National Labor Relations Board, whose goal would be to enforce rights rather than mediate disputes. It passed the Senate in May of 1935, the House in June of 1935, and was signed into law on July 5th, 1935. The law's main purpose was to establish the legal right of most workers, with the exception of agricultural and domestic workers, to organize or join labor unions and to bargain collectively with their employers. The National Labor Relations Board was able to determine, if asked by employees, if an appropriate bargaining unit of employees existed for collective bargaining. So what does that mean, an appropriate bargaining unit? When we talk about collective bargaining, either in this context or in modern context, to be able to bargain collectively with your employer, you need to have an appropriate group of people to bargain. That would normally mean people who have similar positions or are in a similar location or have similar working conditions, because it wouldn't make sense to bargain with a group of people who did not have those similar conditions, because your interests would be different. So a unit appropriate for bargaining, a group of employees who have enough common interests to make bargaining make sense. The board also could conduct secret ballot elections in which employees could decide whether to be represented by a union, and also to prevent unfair labor practices by employers. So what were these initial unfair labor practices that were included? So employers were forbidden from setting up a company union. And that sounds very odd to us today because we don't really have company unions anymore. But what it would be a company sets up what it represents as its own union, and that's who you have to go to. So it's the company representing you for the company, basically. The company bargaining with the company over your interests. So companies weren't allowed to do that anymore. No more company unions. They also were not allowed to fire or otherwise discriminate against workers who formed unions, and they couldn't refuse to bargain with any union that had been certified by the National Labor Relations Board. The act could only apply to operations impacting interstate commerce, which Congress was empowered to regulate under the Commerce Clause, but which really got to the heart of what Congress was trying to prevent here. And that was the kind of disruptions in goods, in services, in the flow of people that happened when industries that went state to state had workers who engaged in strikes. So the Wagner Act, the National Labor Relations Act, was found to be constitutional by the courts, but it was not particularly welcomed by employers. The law and the NLRB were both thought to have a pro-labor bias. But what's interesting is the American Federation of Labor, the AFL, was also not happy with the act. The AFL, since the 1890s, had focused on craftsmen. And when we think about unions and we think about what is today the AFL-CIO, we tend to think about factory workers and that they represented factory workers. But the AFL, in its origins, focused only on people in trades and did not represent any industrial workers. In 1935, there was a split in the labor movement regarding whether the AFL should organize and represent industrial workers in mass production industries, who at that point in time were largely unrepresented. At the AFL convention in 1935, the industrial union leaders, including representatives of the United Mine Workers, the Amalgamated Clothing Workers, the Ladies' Garment Workers, and International Typographical Union, openly clashed with the craft leaders at convention. This led in 1936 to the industrial unions forming the Committee for Industrial Organization, the CIO. The CIO's purpose on its founding was to organize industrial workers to eventually bring them under the banner of the AFL. The AFL demanded that the CIO disband. The committee refused, and in 1936, the AFL suspended most of the CIO unions involved. The CIO reorganized and changed its name to the Congress of Industrial Organizations. Neither one of them particularly cared for the NLRB. The AFL claimed the board was pro-CIO. The CIO protested decisions were favorable to the AFL. Meanwhile, employers continued to criticize the National Labor Relations Board, and in 1939, there was even a series of congressional hearings about whether the board had a labor slant, conducted by Representative Howard Smith. Then we move into a period of relative labor peace. During World War II, there was a lull in the strike action as many labor unions had signed non-strike pledges to support the war effort. This ensured production would continue running, but it also meant there was a buildup of labor disputes. During the war years, union membership doubled from 7.2 million in 1940 to 14.5 million at the end of the war. Now, don't get me wrong, there were some strikes during World War II, but they did tend to be small and localized, and most occurred over disciplinary or management issues. Those small strikes ended after the war, as did the no-strike pledges, and workers across the country again began expressing frustration with wages and working conditions by engaging in a series of strikes. Between the end of 1945 and into 1946, these strikes involved over 5 million people. No year before or after 1946 saw more strikes with a larger percentage of people on strike or more industries impacted by strike. On January 19, 1946, at more than 1,000 mills across the country, 800,000 steelworkers walked off the job. There was a telephone strike, a meat packer strike, a strike at General Electric, and on April 1, 1946, John L. Lewis of the United Mine Workers called a nationwide coal strike. At this same time, there was yet another railroad strike looming. Negotiations between railway management and 20 different unions were not progressing. Negotiations fell apart in April 1946, and a strike was set and planned for May 18th. On May 17th, Harry Truman signed Executive Order 9727 for the government to seize and operate the railroads. Union leaders agreed to postpone the strike for another 5 days. However, negotiations with the White House were unsuccessful, and on May 23, 1946, the strike began. By the following Saturday, the Los Angeles Times reported a complete transit tie-up and the heaviest auto traffic reported in the city's history. The newspaper had to publish a reduced edition with no advertisements. Its paper shipments had been held up by the strike. The Southern Pacific Railroad alone estimated that 17,890 freight cars, 3,000 of them carrying perishables, were tied up on its lines. In California, the potato harvest in Bakersfield couldn't continue without railroad cars to carry the crop, and that put 8,000 workers out of a job. 4,000 citrus workers in Orange County were out of work. Shipments of butter were cut off from the Midwest. Out of 175,000 passenger trains normally in operation, only 100 ran. Fewer than 300 out of 24,000 freight trains delivered commodities. In the U.S. House chamber, President Truman called for temporary emergency legislation to authorize the president to draft the striking workers into the armed forces. This drastic step never happened because settlement of the strike was reached. But the House of Representatives passed that bill to draft striking workers. It was subsequently defeated in the Senate. All of this labor unrest in 1946 ultimately leads to the Taft-Hartley Act in 1947. It was also known as the Labor Management Relations Act. These were amendments essentially made to the existing National Labor Relations Act to try and ensure the continued flow of interstate commerce while also protecting worker rights. The purpose of Taft-Hartley, as stated by Senator Robert Taft, was to weaken the power of labor unions. The bill's co-sponsor, Representative Fred Hartley Jr., said the purpose was to break unions down to the local level. And I want to stop to think just a minute about why maybe that language would not have been as inflammatory to the public at that point in time as it is now. If we think about the disruptions in goods that we experienced during COVID-19, how hard it was for us to get things because goods couldn't come to port. If that was your frame of mind as a citizen, as a business person in 1946-47, you're sitting here, you're waiting on goods to sell, you're a worker who can't work because of a strike, you might have thought the unions at that point were too powerful. So it wouldn't have been the kind of inflammatory message that we would hear it as today, because you wouldn't hear as many politicians openly saying, yeah, we think we need to weaken unions. But that was the climate at the time. So what provisions were in Taft-Hartley that people thought might weaken unions? Taft-Hartley outlawed secondary boycotts and strikes. So under Taft-Hartley, workers could only pressure their own employer. You can't go and say, refuse shipping to struck locations if you're a trucker. Workers can't refuse to handle goods that have been produced by strike breakers. You can only go after to pressure your own employer. Taft-Hartley outlawed jurisdictional and wildcat strikes. So unions would risk fines if their members went on strike to get an employer to assign work to one union instead of another, or if they struck without union authorization or struck in violation of a contract. Taft-Hartley also segregated professional employees. So professional employees could no longer be in the same bargaining unit with non-professional employees unless the professional employees voted separately to be included. Taft-Hartley excluded supervisors from the bargaining unit. Before it was passed, frontline managers were often included in union bargaining units. It weakened industry-wide bargaining. The law bars unions from pressuring employers to bargain as part of a larger employer group. It outlawed the closed shop. So a key union goal prior to Taft-Hartley was a closed shop in which employers agreed to hire only union members. Taft-Hartley also enabled the state passage of right-to-work laws that barred union contracts requiring workers to pay union dues. 28 states essentially passed such, or later passed such acts. Taft-Hartley also allowed captive audience meetings. So what is a captive audience meeting? It's where an employer, if the employer thinks the employees are organizing or knows the employees are organizing, can hold required meetings with those employees to give them the employer's viewpoint on unionization. Though, note, this is something that may be changing under our current general counsel at the NLRB. Taft-Hartley required union leaders to sign affidavits that they were not members of the Communist Party. That led to the expulsion of many union workers at the time. The CIO Labor Federation ejected 11 communist-led unions, totaling over 1 million workers. It took financial power from some of the unions. Taft-Hartley barred employer contributions to health, welfare, or benefit funds if the funds were solely controlled by the union. That's why today in many industries, you will see that their pension or their health benefits are in what's called a Taft-Hartley plan, where it's administered jointly with an equal number of employer and union trustees. It set time limits on when you could file a charge. If you have an unfair labor practice charge that has been committed, it has to be filed within 6 months. Taft-Hartley also gave the president power to halt strikes. It has rarely been used, but when an industry-wide strike does threaten national health and safety, the president can order strikers back to work. So Taft-Hartley, in addition to weakening unions in some people's view, also did strengthen employee rights. Section 7 of the Act, which still exists today, gives employees the right to either participate in union or other protected activities, but also gave employees the right to refrain from such activities. Taft-Hartley additionally defined 6 unfair labor practices to address conduct by unions that could infringe on employee rights. So no longer were unfair labor practices able to be committed just by the employer. The amendments protected employees' Section 7 rights from restraint or coercion by unions and said that unions could not cause an employer to discriminate against an employee for exercising Section 7 rights. Although closed shops were declared illegal, the Act provided employees could sign a union shop agreement under which employees could be required to join the union on or after the 30th day of employment. The amendments also imposed on unions the same obligation to bargain in good faith that the Wagner Act had placed on employers. The other thing that the Act did do was create an NLRB General Counsel. When we say that we are the General Counsel, I work for the Office of the General Counsel. We are the arm of the board that investigates and prosecutes cases. We are separate from the board side, the NLRB itself, which adjudicates those cases. So that change was made as part of Taft-Hartley. The General Counsel is appointed by the President, subject to Senate confirmation. The General Counsel is a prosecutor separate from and independent of the board and supervises the agency's attorneys. Truman initially vetoed this act and described it as a slave labor bill, but his veto was overridden. Labor believed that Taft-Hartley limited labor strength and leverage as it was written to prevent the kind of general, powerful strikes that occurred in 1946. There was an attempt then to repeal Taft-Hartley in 1949. Everyone seemed to agree, liberals, labor, conservatives, and moderates, that some sort of revision was required to Taft-Hartley. The debate over repeal lasted 6 months in 1949. Taft himself offered a list of amendments that would have passed, but for labor's insistence that only full repeal of the act was acceptable. So everyone agreed change was necessary, but there was no consensus as to what that change should be. In 1952, there was a steel strike, and their contract had expired on December 31st of 1951. Negotiations had not produced a new agreement. The steel workers announced that they were going to call a nationwide strike. It was in the midst of the Korean War. Truman had warned that such a strike would threaten the national defense. So he had a choice. He could refer the dispute to his wage stabilization board, or he could use Taft-Hartley to handle the strike. Taft-Hartley allowed but did not require the president to seek a court order stopping a strike for 80 days if the dispute threatened health or safety of the country. During the 80-day cooling off period, the government would attempt to settle the dispute. The president could then submit a recommendation to Congress. Truman decided not to use Taft-Hartley. He thought it was a peacetime labor law, and he believed that due to the war, more direct government action was required. So the dispute was sent to the Wage Stabilization Board. The steelworkers agreed to postpone their strike, but after 2 months of meetings, the Wage Stabilization Board sent a report to Truman. It recommended a wage increase of 26.4 cents an hour over 18 months, lower amount than the union had demanded, but the union was prepared to accept the increase. The problem, the steel companies wanted an increase in the prices of steel. There were controls on these things at the moment because of the war, and Truman refused to grant them that increase. Last-minute attempts to negotiate an agreement failed. The steelworkers voted to go out on strike on April 9th, 1952. The night before the strike was to begin, Truman issued Executive Order 10340, directing the Secretary of Commerce, Charles Sawyer, to take possession of the steel mills. Reaction was immediate. Steelworkers praised Truman, postponed the strike, but steel companies criticized him, with some members of Congress referring to him as an American Hitler. On June 2nd, 1952, Truman's seizure of the steel mills was declared unconstitutional. And that leads us to the presidential campaign of 1952. This is the landscape that existed leading into Eisenhower's presidential campaign. On June 1, 1952, the day before the court's decision in the steel mill case, Eisenhower returned to the United States from Paris to fight for the Republican nomination and announced his candidacy on June 4th, 1952. Not only were labor and management at odds, labor and labor were at odds. The railroad strike was still within memory. The steel strike was fresh. It was clear labor was going to be a primary issue differentiating the parties. During the 1952 campaign, Democrats called for repeal of Taft-Hartley. So the first difficult choice Eisenhower had to face, how to address this issue during the campaign. The 1952 Republican Party platform said the Republican intent was to revise the act by urging the adoption of such amendments as time and experience show to be desirable and which further protect the rights of labor, management, and the public. So what exactly does that mean? I'm not sure, but it really sounds good, right? So fundamentally, the Republicans didn't want to throw Taft-Hartley out, but they hadn't yet really determined how it should be amended. As noted previously, Taft himself, who had been one of the act's sponsors, had already said there were necessary revisions. So where did Eisenhower come down on the issue? He did not offer specifically worded amendments during his campaign, but did provide some ideas of where he thought change could be made during his addresses. Based on his speeches, he believed that labor and management should be able to work out their differences through collective bargaining, with the government mediating more than mandating. Eisenhower addressed the AFL convention in 1952, and in that speech set out his belief in limited government involvement in labor disputes. He stated, "Certainly there is enough responsible leadership in industry and in the union movement on which to build the foundation for labor peace." He promised to, quote, ask the advice and suggestions of all groups, public, management, and labor, as he went to determine his labor policy. Interestingly, Eisenhower also stated a belief that labor was not a unified political bloc. He said he believed that all slanted partisan appeals to the men and women of labor, any design to make them a kind of political bloc, was an affront to the dignity of labor and a disservice to the unity of America. He promised, "To the limit my judgment can discern, you will always get both justice and fairness from me. I will always try to be a true friend of labor." Regarding Taft-Hartley, Eisenhower expressed his support for amendments to Taft-Hartley to eliminate provisions that could be used to smash unions. He denounced compelling workers to settle disputes and work against their will. He also called back to that railroad strike and stated that he had threatened to Truman to quit the Army if in 1946 Truman had drafted those striking railroad workers. Eisenhower carries this philosophy of labor management cooperation over governmental interference into the presidency. In a State of the Union address in 1953, Eisenhower spoke about Taft-Hartley, stating that experience has shown the need for some corrective action, and we should promptly proceed to amend that act. Eisenhower stated he believed in the basic principles of the Taft-Hartley Act and was opposed to its repeal, which brings us to the next set of difficult choices: how to reach consensus on amendments to Taft-Hartley, and how to choose advisors that could help broker that consensus. Eisenhower was impressed by people who had risen to the top of their chosen fields outside politics. The senior ranks of his administration were full of people with achievements in the military, business, law, and education. Most of his cabinet were very wealthy men. Into this cabinet, he appoints Martin Durkin, a trade unionist steam fitter out of the United Association, as his Secretary of Labor. And some Democrats then referred to the cabinet as 8 millionaires and a plumber. But it showed Eisenhower's willingness to put principle into practice, providing a voice for labor on the cabinet. So Durkin was from Chicago. He was a steam fitter by trade. He'd been a business manager of Steam Fitters Local 597, but he had also been the head of the Department of Labor in Illinois for 8 years. And he was a member of the Defense Mobilization Board and National Security Resources Board under Harry Truman. So he was not without governmental experience. He was one of only 2 members of Eisenhower's cabinet who had experience running the kind of governmental department he was taking over. Though the New York Times did report in December 1952 that Durkin himself was mystified by his selection as labor secretary. News articles about Durkin's appointment stated that Durkin's priorities included moving the NLRB from its status as an independent agency to within the Department of Labor. And on Taft-Hartley, though he had been a strong opponent of the law when it was passed, he did believe that the law should be amended, not repealed, to find a law acceptable to both labor and management, the view that was taken also by Taft and Eisenhower. Durkin told the Musicians Union that he did not intend himself to propose amendments, but rather to help Taft and labor leaders iron out their differences. Durkin was also quoted as saying he believed labor groups should not look to the government to settle their disputes, that issues should be worked out between the parties. So this is a commonality of view that he did share with Eisenhower. He was a Democrat among Republicans on the cabinet, and Eisenhower is said to have told Durkin, "I want you for your heart and brain, Martin, not for your political influence." With Durkin's appointment, organized labor had a voice in the cabinet, and it appeared the administration was positioned to seek amendments to Taft-Hartley, as both the Republican platform and Eisenhower's campaign speeches had stated. On January 28, 1953, the New York Times published that Senate Majority Leader Taft had offered for congressional approval 16 amendments to Taft-Hartley, contained in 5 separate bills. 2 of the amendments were said to be reforms proposed by Eisenhower during his campaign. On February 9, 1953, Taft announced after a White House visit that amendment of Taft-Hartley was included in the president's 11-point program for congressional action in 1953. And yet, during 1953, ultimately no amendments were passed. So what happened? The answer depends on who you ask. Durkin's account in later interviews represented that as soon as he took office, he set up a tripartite advisory commission to develop amendments. It failed almost immediately, with Durkin blaming an employer member for the committee's failure. Then there were a series of conferences held between the Commerce Department and the Labor Department. Durkin declared these fruitless because the 2 departments were so far apart in their viewpoint. At that point, Durkin said he submitted the Labor Department's proposal to the White House, starting a new series of conferences, some at the White House, some in Taft's office. These efforts did not reach a full proposal, but were able to find tentative agreement on some points between the various players. Durkin then represented that he had met with a representative of the White House, and that the 2 of them had reached a full 19-point agreement on amendments, and that those 19 amendments had been on the president's desk, ready to be sent to Congress when White House support was suddenly and abruptly withdrawn. By contrast, Time magazine, in its September 21, 1953 issue, presented the timeline like this. From January to June 1953, pro-labor and pro-management forces in the Eisenhower administration negotiated a list of changes to be made to the law. It was understood that getting all the amendments passed would take a hard press by the administration. The final list of proposed amendments was worked out by a group of non-governmental leaders, and there were a total of 16 changes. On June 16, 1953, Durkin approved the list, with the exception of one issue: how the law should say that a closed shop could be permissible in the building trades. On June 17, 1953, George Meany, then president of the AFL, studied the list and raised 2 objections. He seconded Durkin's point about the closed shop in the building trades, and also objected to another provision about replacing the NLRB with a labor court. Then Department of Commerce General Counsel Stephen Dunn also took a look at the list. He had a couple objections as well, primarily because there were things that he thought should have been included in the amendments that benefited management that had been left out. In late June 1953, White House meetings were held, with Commerce again objecting, and Durkin giving the impression that he would go along with all 16 points on the list. Taft represented that they were making progress, and Durkin circulated the 16 points to various union leaders. In early July 1953, George Meany of the AFL heard that many other labor leaders didn't approve the list, that they weren't on board. Durkin then heard that rivals within his home union, the United Association, were using the list against him, accusing him of selling out. Meanwhile, the White House pressured Commerce into giving in and approving the list. Durkin then started backing away due to union pressure. During the week of July 20th, Durkin raised a new objection to the secondary boycott provisions. He announced he saw the whole proposal as a package and would therefore not accept other points, that the whole 19-point deal or 16-point deal was a take it or leave it deal. And so he therefore would not accept any other points. In late July of 1953, Durkin's Labor Department drafted a new 19-point program more favorable to labor. Commerce was left out of the discussions, and Durkin received a White House aide's personal buy-in on that list, but not the actual White House aides, and then released it to the press on July 30th, 1953. On August 19, Durkin spoke with Eisenhower and failed to get his buy-in on the 19-point program, and on August 31st, Durkin submitted his letter of resignation. So what is not in dispute between the accounts? So there was a preliminary draft of Durkin, the Department of Labor's proposed amendments, not the previously agreed upon 16 amendments. And those were indeed on Eisenhower's desk on July 30th, 1953, when Eisenhower was notified that Senator Taft had died. On August 3rd, 1953, the amendments were published in full by the Wall Street Journal. They were seen as more favorable to labor because that is how Durkin had drawn them up. These were his 19, not the 16 agreed upon by the group. And business leaders and the right wing of the Republican Party revolted. The amendments were never sent to Congress. Durkin resigned, stating that the president had promised to support the proposals, but had been prevented from doing so at the last minute by Vice President Nixon. The official White House response was that the proposal was merely a preliminary draft, and that Eisenhower had never offered his full support. Following Taft's death, Senate Republicans elected William Knowland as the new majority leader, bringing a more conservative slant to the Senate Republican leadership and lessening the chances of gaining the majority leader's support for any cooperative amendments. So what did Eisenhower say about this? He did actually diary about the events of August 1953. And he noted that he had met Durkin because he was getting the feeling in July, August of 1953, that Durkin was seeing himself more as a representative of labor on the cabinet rather than Eisenhower's principal advisor on labor. Eisenhower said, "It seemed to me he kept thinking of himself as an employee of a labor union serving on the cabinet merely on an interim basis while on vacation from his true work and position. Consequently, I expressed to him the very earnest hope that he would give the rest of us in the cabinet his very own convictions and conclusions based on his lifetime experience and study. I told him if he served through these 4 years as an independent individual, giving the best he had to the administration, I would personally guarantee him a job, a good job, when the next administration took over." So he says Eisenhower then in his diary that Durkin appeared touched by this statement of purpose and told him that the group had been making progress towards reaching conclusions about what should be recommended to Congress. And Eisenhower then tells him, "Of course, if all my advisors are unanimous in their recommendations, I am happy to send their conclusions along to Congress." Such a promise was, of course, based upon my knowledge of the diverse views that were represented on the committee. So we see in Eisenhower's own words, he was not going to agree to anything partisan or one-sided. He wanted something collaborative, cooperative, and not a partisan view. So as I am running out of time, I am going to skip quickly to talk about, so do we think this was a bullet dodged or an opportunity missed? I think it does depend on your viewpoint. I think it is a missed opportunity in that anyone who looks at politics, anybody who examines or follows politics knows it is very, very rare to have a circumstance where everyone agrees that there are changes that need to be made. It's rarer still to have a group of people willing to collaborate on those changes. And it's even rarer still to have people in all the positions of power who can make those changes happen. There was a very unique moment in time here where there was a cooperative cabinet, there was an administration willing to push to get the job done, and a Senate majority leader before Taft died who was willing to push things through in the congressional side. At the end of the day, we don't know what might have come out of this collaborative process. And I think it is definitely an opportunity missed. In terms of a bullet dodged, I think it depends on how you look at these amendments. We've, as I discussed earlier, have seen an uptick in strike activity. Would it be a bullet dodged if we didn't have to worry about, as we don't have to worry about right now, big generalized strikes? Or is it a missed opportunity to have more power and voice for our labor force? And again, I think that depends on your view. So with that, I am happy to take any questions that you may have.
Right. Well, thank you. We have a few questions in the chat, and I have a few questions. So we'll jump right in. So the first question is, isn't the disruption the point of a strike? Isn't disruption the point of a strike? Isn't that how change happens?
It absolutely is the point of the strike. I think what the policymakers who were interested in reducing strikes would tell you is the disruption was, obviously, to repeat the word, disruptive to the flow of goods and services in the US. They felt it was disruptive enough that it was interfering with the way the United States conducted business, with the way people earned their living. And for instance, one of the reasons it was found when Truman took control of the steel mills, one of the reasons that was found to be unconstitutional was it wasn't considered to be by the Supreme Court a big enough threat to justify that kind of takeover. So yes, it is the whole point, and that is indeed what the policymakers wanted to limit.
Okay, that's an interesting take. I'm going to come back to that. Why did Taft-Hartley exclude professional workers and supervisors?
Taft-Hartley, okay, are you asking for my viewpoint or probably the real reason? Probably the real reason is so that you would not have workers working collectively to bargain with their direct supervisors. The official reason would be they don't have enough commonality of interest, that when you have someone who is supervising an employee, that person cannot bargain for that employee's interest and their own interest, because their interest is not necessarily the same as the workers that they are supervising. If I have an obligation to supervise your work, give you true and accurate feedback about your work, do your evaluation, if we are in the same bargaining unit and bargaining together, I may not be able to do that from a viewpoint that would be neutral.
Huh. That's interesting. I wouldn't have thought about that like that. Okay, the next question is, Taft-Hartley included language which mandated employees sign anti-communist affidavits. How was this handled? And was McCarthy behind this additional provision?
I don't know who exactly was behind that provision. I did not go back in the labor history for that. What you will see is, if had we gotten to some of the proposed amendments by Durkin, one of Durkin's proposed amendments was that both employees and management, so labor unions and management, would all have to sign those anti-communist affidavits. A lot of the politicians at that point in time, including if you read some of the literature about Eisenhower is pretty anti-communist as well, although he was not involved in politics at the time the original Taft-Hartley was passed. But I don't know that we can tie it necessarily to one politician's door. There was a strong anti-communist feeling and movement at that time.
Okay. All right. So this next question is kind of going to circle back to that first question. So I don't know a ton about early labor history, but I do know some because we study it as historians and we study it as educators. So early labor history shows that, abysmal work conditions, long hours, low pay, and unions, helped change all of that. So were there people who supported the Taft-Hartley Act that did so in an effort to reverse the strides that unions made for workers?
Well, yes. I mean, it was pretty apparent that some of the people who passed it wanted to be able to reduce union influence. That was stated by Taft that that was one of his goals. They wanted union actions to be more local, more limited, and not as large and national on scale. So it's clear that was some people's goals in the passage of that law. Yeah, that was very clear. Reduce the disruption, reduce the ability of the unions to make that kind of widespread economic impact.
Well, I guess I'm trying to look at, like, I feel like that was kind of going forward, but I'm thinking more like, you know, when we're thinking wages and the amount of hours that people can work, and all the things you talked about, an 8-hour workday and stuff like that. Were there people who looked at Taft-Hartley as a way to try to take some of those away, like the things that were already established?
I don't think so because the purpose under Taft-Hartley was really to be able to bargain those things. And if we look at what collectively bargained agreements look like today, we see that those are the kind of things that people bargain over: wages, hours of work, working conditions. All of those would go within your collective bargaining agreement. So I think what the people who were promoting Taft-Hartley would say from that aspect is that puts the ability in the workers' hands to bargain within their particular industry for what hours and working conditions are appropriate for them. So not take it away. But if we look at a lot of Eisenhower's speeches, we can see that Eisenhower was one too who said that really the government shouldn't have so much control. That really these kind of things should be worked out between workers and management. That's a fairly common viewpoint at the time. That we don't want government sticking their nose into our working relationship. We want to figure it out on our own.
I do want to talk about, you mentioned that Eisenhower was against the shutting down of labor unions. Um, I'm trying to, how do I ask this question? Um, Seeing as, as a presidential candidate, he was running as a Republican, he was a Republican. Um, did that go against what people would have thought his part? He would have thought, being a member of the party that he was. Maybe, I don't know. I don't know if I'm asking this correctly.
In the context of the times, I don't know. Um, there were a lot of voters, I think, who at that period in time would have told you that they believed that the unions were too strong. So the idea was we don't want to get rid of unions. We think workers should have rights. And I think Eisenhower's viewpoint wasn't a dangerous one at the time. The whole view that labor and management should work out these things between each other. It should be cooperative, that labor shouldn't be a block. It shouldn't be like a set voting interest of just labor. There should be a concentration on what the individual interests are between the parties themselves at each employer and employee group. Does that make sense? Did I answer your question?
Yes, yes, I think so. Okay, so we have about 6 minutes left. I don't have any more questions in the chat, and I don't have any more questions. So every now and then, when we can, we like to share things either from our collection that go along with whatever we're talking about, or something from the collection of some of our other presidential libraries or the National Archives holdings. And our friends at the Truman Presidential Library, right? about 2 hours away from us, 2.5 hours away, not too far from you, have a few things on their site that we wanted to share, particularly this political cartoon that came out during the Truman administration, specifically about the Taft-Hartley agreement. And I thought it was interesting because you see the big businesses weaving this spider web, and I believe all of those bees represent, or all of those flies represent a different type of labor union getting caught up in it. When I was a teacher, I would put this on the board and have my students kind of dissect it. So I'm going to ask you, what does this political cartoon kind of say to you?
Well, I think it thoroughly reflects how Truman felt about Taft-Hartley. He did refer to it as the Slave Labor Act, in fact. And I think it shows his viewpoint that it constrained the movement of unions and the power of unions, because if you look at a spider web, I mean, they really have nowhere to move, nowhere to go. And that was the argument that was made, is that the unions are so constrained and trapped by the restrictions in Taft-Hartley that they can't exercise any influence.
That's a very good interpretation. If I was your teacher, I'd be very proud.
Well, thank you very much. Give me a gold star.
All right. Well, it doesn't look like we have any more questions or any comments. So I would like to say thank you so much for joining us. Thank you so much for your presentation. Thank you to our audience members for joining us. And if you'll just bear with us for just a few more minutes, we have a few announcements, and then we'll call it a night. So first of all, we always want to say thank you to our sponsors, the Eisenhower Foundation and the Jeffcoat Memorial Foundation. They sponsor our programs, the 2023 public programs, and we would not be able to have these programs without their generous support. Our next program is our Lunch and Learn, which is the fourth Thursday of this month, August 24th at noon. Of course, you can join us virtually or in person. Our speaker will be in person, and it is Dr. James Young, and he will actually be looking at the difficult decision for President Eisenhower to run for a second term after having a heart attack. And then in September, our next program is our Lunch and Learn on Thursday, September 28th. We will welcome Dr. Philip Joyce, and he will talk to us about Eisenhower's budget and his decision to try to always have a balanced budget at the end of each term, each year of his presidency. If you'd like to learn more about our programs or just know when we're having them and when they're coming up, feel free to join our email list. You can find that at eisenhowerlibrary.gov, and we will send you whatever we have going on. Thank you again for joining us. I hope you all have a wonderful evening, and we'll see you next time.